Hi, welcome to Legal Tech Diaries. As you know, my videos are split into two parts. First, we discuss the legal side of the topic, and then we shift into legal tech side to understand how it works in modern law practices. So today we're going to talk about one of the most important and fundamental topics in law, the contract. So, first of all, let us understand what is a contract, the definition of the contract. Contract is an agreement which gives rise to obligations. Obligations that are enforced, so either enforced or recognized by law. It is how to objectify the promises and expectations both in daily life and business. So now we know the definition of the contract. But when the contract, in which cases the contract is legally enforced and valid. So for that the contract would be legally valid and enforceable, there need to be the three core elements. The first one, the agreement between the parties. The second one, intention to create a legal relations. And the third one, consideration. This is like something of a value that can be exchanged between the parties. So we know also the three core elements, but let us go deeper and break down each of them and discuss separately. So the first one, agreement. Each contract starts with an offer. Offer is a proposal of one party, the offerer, to another party, offeree. So usually it comes with a promise. If you accept the terms of the contract, I will be bound with them. So this is, the offer. What does it mean, offer? And the offer could be have different forms. It can be in a written, it can be in a spoken loud form, or even it could be through actions. But the offer should also be valid. And the offer to be valid, it should be complete, it should be operable, and it should have also a strong intent that it can be legally bound with anybody who accepts it. And this acceptance, how and when the acceptance starts, it's also very important for this situation, for the contract. The acceptance comes with the offeree's final and unconditional acceptance of the terms of the contract. So that means once the acceptance happen, the contract starts shaping its legal, it's starting to be legally shaped. So this was the first element, But as I said at the beginning, it should be three core elements so that the contract would be legally bound. So that's why we're switching to the second one, because just accepting the contract is not enough. Accepting the terms is not enough. So for that, we need the intention of both parties. So with the intention, we meant that the parties want to have legal obligations rather than just a casual social or domestic arrangement. To understand if there is an intention, we can assess it by court. The court can do this based on the facts. So now we have reached the third core element. And the third core element is the consideration. Consideration is essentially the exchange. That means that the parties promise to do or get something of value. It can be the goods or services received. That means that with acceptance, with consideration, yeah, with the exchange, the parties, yeah, this transformed, they transform their promise, yeah, the simple promise into legal obligations. So we have discussed all three core elements, but beyond these core elements, there are also essential other elements which are required for the contract to be legally valid. So the first one is capacity to contract. So what does it mean? It means that the parties should legally be able to enter the contract. So that means that if it is not valid, it's invalid if the one of the parties or maybe both of the parties, yeah, are mentally incapacitated. The second essential element would be uh, consent. So, what does it mean? Consent means that the parties should enter the contract freely. So, if the party, yeah, entered in a contract under the force, it can be duress or undue influence, this contract, yeah, this consent could not be valid. The third one is legality. So legality means that the contract, yeah, the purpose of the contract should be lawful. So it should be a legal activity. It couldn't be illegal activity. Yeah, it should be illegal, and it couldn't be against the public policy. So the next one would be certainty. The certainty means that the terms of the contract, they should be clear and definite. And that means that if the contract terms are vague or incomplete, then this can be declared as void. This can be declared as valid, so it can be declared as void. And this is like in the case of the Scammell versus Scammell and Nephew versus Austin 1941. And the last one, form. In the beginning, I've told you that the offer, yeah, that the contract can be in three forms. It can be in a written, made, yeah, spoken aloud, or with the actions. But there are some contracts that must be in a written form. Examples of this could be deed and guarantees. So we have talked also about the essential elements of the contract. And now let us talk about the forms, which can be different based on the structure of the obligations, how the obligations, yeah, are structured. So the first one, not the first one, so we will talk about two, yeah, unilateral and bilateral contracts, and see the difference between them. So the unilateral contract is when only one party make the promise. And this could be an example like a reward for the lost pet. And the other party should and could, yeah, accept. So he is accepting by, yeah, providing, performing the requested act, and there is no communication needed, yeah, between them. In contrast, the bilateral contract is when there is a mutual promise for an exchange. So these were the both unilateral and bilateral. And let's talk now about the status of the contract, and how it is treated in law. We would talk about voidable, and unenforceable contracts. So let's start with a void contract. The void contract is not a contract at all, because it's treated as if it never existed. Yeah. In this case, any goods exchanged, they should be returned. And if the goods have been resold, the original owner should be might recover them. The voidable contract is the contract which is, it begins already valid, but the parties can choose to cancel it. That means that if the goods or money has been already exchanged, they should be returned back. But if the good is resold before the contract is void, then the original owner cannot reclaim it. The next one and the last one is unenforceable contract. And an enforceable contract in theory is valid, but the court um, will not enforce it when one of the parties breaches it. That means that the party cannot sue the other party to perform their obligations. In this case, also the goods, which has been exchanged, they could not be reclaimed. Now we have reached to the part when we want to understand the rights when it is a contract and the property rights. What is the difference between these two? And the difference is very interesting and with two Latin words. The first one is the contract law, and the contract law in contract rights starts with persona, and persona is word, so translated, it's a Latin word which is translated against the person. So that means that in this case, your contract rights, there are a special for the specific person. So you can enforce the obligations, the promise, only from a specific person. For example, if you sign an agreement with your neighbor, you can enforce the promise only from him, for this person, not anybody else. In contrast, when you are in a property, you have a property rights. This is the rights of rem, which is again a Latin word, and this is the translated against the world. And against the world means that nobody can be against you, and you can be against one person, but against everybody. And that means that anyone who interferes your property, you can stop them. So you can stop them to build, for example, on your property. So with this, we have reached the legal part. So we have understood the agreements, how the agreements, begins to as an obligations, and how these obligations, are governed by law. And now we can switch to the second part when we're talking about the legal tag of the same topic, the same topic in legal tag. So we have explored the foundations of contract law, and now we can zoom into the technology, how the technology, especially the legal tech, transforms the creation, the way how the contract created, managed, and enforced. So first of all, let us see the process of the contract and legal tag. So traditionally, how to form the contract. So traditionally, the offers, the agreements, the signing, all these processes, they take part on a paper and during the physical meetings. But in this case, in the digital world, when there are digital platforms like DocuSign, this can happen, remote, and the person can sign, the person can, yeah, send and negotiate and everything on a platform. This means that it has also not, it's not only faster, but it has also the positive side of ensuring that the offer is clear, that the acceptance has been logged, or yeah, everything has been signed. So the next one would be the identity verification, no, the payment, yeah, validations. So the payment validations can be integrated in such a platforms, and it could be verified your consideration. So it would check automatically if a good, yeah, has been exchanged. And this will link to obligations and in a real world outcomes. So this will check if the core elements, one of the core elements, yeah, consideration has been met. So the next one would be the contract, yeah, smart contracts. And the smart contracts are the ones uh, that are written, yeah, in a code and mostly on blockchain, and this can self-execute. That means that if the terms are met, yeah, if the conditions are met, the it can automatically, yeah, do the process to do an exchange, and yeah, it would be easy, and there would be no need again of a human person, because if it's met, yeah, if the condition is met, then if it's performed, that means that that the that it can automatically be transferred. So the next one would be the AI driven draft tools, which scan a very huge amount of documents, and this can help to find out if the terms, yeah, certainty terms are met, or if the clauses are also valid, yeah. The consent, and this would flag all the risks, and this would check the, yeah, validity, the acceptance, and the other essential topics. So the next one would be, yeah, the capacity about which we have talked about, yeah, in the legal part. And this capacity would be also checked with legal tag. So that means that it would be automatically checked if the with the KYC, this is know your customer tools, it will check if the parties can and may, yeah, if they are able to enter to the contract. So it will help a lot of vulnerable parties to be, yeah, ensure that they are able to enter to the contract. And the last, the final one, yeah, we have reached is the importance, yeah, the smart contracts, and this would, as I said, yeah, this smart contracts are not only making the life faster, but it serves, yeah, as an evidence that everything, all the conditions or the elements are met. So that was all about the contract core elements, and both in the legal, yeah, classical legal aspect, and in a legal tag. So that was all for today's episode. See you in the next episode. Thank you.